may be seated. All right, we're on to our third case of the morning, which is 25-15-35, Leroy versus State of Florida. And counsel for the appellant has filed a request to show a video, which we've granted. And when you get up to the podium, before we start your time, just tell us kind of what you have in mind of where you're going to show that, or when, rather. So, go ahead.
May it please the court, I would like 5 minutes for rebuttal, Your Honor, please.
Okay.
I'm Rick Sikta from the Sikta firm, and I represent Jalen Leroy. This is a direct appeal.
Okay, when are you just going to at some point go, I'm going to show the video and then show it, or?
I'm going to show it right after this initial statement, Your Honor, and I'll tell you
Then
why.
we'll go ahead and start the time.
Yes, sir.
Thank you.
Your Honor, this case comes down to whether this was reasonable shooting one time an individual that's caught on video. Both parties have said, watch the video and determine. This prosecutor, who has been called out by name by this court for committing misconduct, took this case away from the jury, poisoned their minds with saying such comments as, if you find this action reasonable, bodies are going to drop in Jacksonville. The community conscience argument. He also said self-defense is preemptive. He also said you can't shoot first and ask questions later. He also said that this individual that was shot, Mr. Allen, had his pockets in his hand the whole time and was not a threat. I can show this court right now something that no one has ever caught before, and I would like this court to see it, and when you see it, I would like you to take this oral argument from that perspective, because our job in this case, from Smith v. State, which came out from the 6th DCA very recently, June 27, 2025, the reasonableness of a person's belief that a use of deadly force was necessary is measured by an objective standard. But, quote, whether the person's belief was objectively reasonable must be determined from the point of view from the person that's shot. So we need to take off our ties, our robes. We need to get in Jacksonville at 11:30 at night where it's hot. We don't have security guards. We start there, and I would like to show you the video of what we see and to see if you see it, which will change the entire evidentiary landscape of this case the way you look at it.
So are you saying that this video is going to say that there was fundamental error in the arguments being made by the prosecutor?
This video is going to show that this was such a close case. This prosecutor took it over the level by scaring the jury to convict this guy by saying that his actions were not reasonable and that people that shoot create a self-defense narrative.
Because this is what the jury saw, is what you're telling us.
Yes.
Okay, and so they didn't buy the self-defense argument, right?
Well,
Well, they convicted him, so if they didn't,
lesser included. They charged him with second-degree murder. They came back.
they didn't acquit him if he wanted to be acquitted based on self-defense.
Correct. And my argument is that prosecutor took it over the line. Both of them did. And if you read the arguments in there, the community conscience argument is clear. He also said narrative, people that, anybody, he used the words anybody, he didn't say my client. And he also said people. People create narratives of self-defense when this happens. So he's getting the jury to get so scared. And before he said the bodies will drop argument if you convict this guy, he brought the jury back into a grocery store, similar to Swofford, where he's saying, we can't have this lawlessness, we can't have this legislature. He said that if you go into the grocery store, people are probably carrying guns that you don't even know. And the next thing he says after that is bodies will drop if you find this reasonable, and he ends his initial closing argument. May I show the court what we see?
Yes, go right ahead.
I have a timeline, but I don't know if the courts have a video available to them, but I would go through the
We
timeline.
have.
Yes, sir.
Which exhibit is this?
This is Exhibit 2, Your Honor, thank you.
Okay.
State's Exhibit 2 introduced to the evidence. We have Exhibit 2 and Exhibit 3. Exhibit 3 is more of a consolidated one. It's the one the jury saw too.
Okay.
This is Mr. Allen in green approaching. This is the first time. Mr. Leroy is here. I have to stop it when they interact for the first time.
Mr. Leroy has kind of a hoodie on with ruffles or something,
He's got a silly hoodie on.
bumps on the hood, right? That's who he is.
And
Yeah.
he's got a bottle of champagne, I think, in his hand. He is a college-educated kid, father, no prior record. He's carrying a gun.
The defendant was carrying a gun.
Correct. And as we find out, Allen was too. will stop it at 6:57. Here it comes right now. And the girl that was with, the state did not talk about in their brief, he was with a girl, her, who said that, you see them right there,
So they just walked by.
they walked by and looked over. I'm not saying that they stared at him, but they certainly gazed at him, probably because of what Jalen Leroy was wearing.
Did your client testify that he did not recognize either one of the individuals?
They're all strangers to him, sir.
Well, the question I have, and we can go right along with this, but when they return, when they're coming back the opposite way from what we've just seen, your client's body language and face changes from chatting with a friend or an acquaintance to a look of concern, doesn't it?
He sure does, and I'm going to show you that right now. He's smiling right here at 7:46, Your Honor, right there. And what the state left out of their brief is these individuals that just passed him. Mr. Harris, he was the one that you will see confronts Mr. Leroy first. Mr. Harris tells this girl, Miss Harris, and excuse my language, this is what the evidence is. I just saw somebody that had me fucked up in the past. The state doesn't talk about that in the closing. It's completely omitted from the state's answer brief. So we know they're coming up there not to exchange pleasantries like the state said in the closing argument. Mr. Leroy testifies and he tells the police 5.5 hours. He voluntarily talked to the police that it was self-defense and the guy was reaching in his police. At 7:52, here's Mr. Harris. Can't stop, I'm sorry, I'm that person. If you saw, this person points at what Mr. Harris is doing. Mr. Harris approaches Mr. Leroy from behind. Remember, these are strangers. And he stares at him the whole time. So now, remember.
Which one's Mr. Allen?
Here.
Okay.
This is the important part that no one has talked about before. So we have Mr. Harris here now. We're out in the street. This is us, reasonable person standard. You have somebody confronting you you don't know. Jalen Leroy has now taken 2 steps back. He has now taken the position, and now Mr. Allen enters through. And Mr. Leroy testifies, no, I don't want anything. I don't want this to stay in the closing arguments that Mr. Leroy and everybody else agree that Mr. Leroy just said, what's up? That's false. Mr. Leroy said, this guy said, what's going on? The state left out of the brief that Mr. Dunn, this right here, he also said that Mr. Leroy told him, or that Mr. Harris said, hey, you know so-and-so. He's trying to find out who fucked him up in the past. Mr. Allen is a 2-time convicted felon carrying a gun in his right interior jacket pocket. I want you to watch again later. When they pass, Mr. Allen's got his jacket up. Watch this. His hands are out of his pocket, correct? Right there. 7:56, so I can catch it. Right there. He is so good at doing that, you don't catch it until he takes his left arm, zips his jacket. Now look at his jacket. Now it's down to there. His gun is right there. Now he puts his hand down his pocket. He's taking interest in Leroy. Now Leroy, now you're 2-on-1 in the streets against strangers, gentlemen.
So this was all told to the jury?
The zipper never came.
So its defense counsel didn't raise it at trial?
Didn't see it. There's one other thing. Watch his hands. This is where the gun is. Got his hands down. You can see they're at belt level. Shoot, I'm sorry. Fumbling with his pocket. Do you see that? Now watch this. Watch the angle of his elbow. It's a fluid motion, and I want to say this to this court. I played baseball in college. I learned how to throw curveballs, are really good at things. This is the most fluid action in a gun I have seen. You saw the zipper, watch what he does with the gun. There. Oh, shoot. If you look back at that, he takes his arm out and he tries to grab that gun.
You need to back it up a little, right?
I'm trying, sir, I'm sorry, I've got.
It's all right.
There it is. And I think, Your Honor, you'll have to watch this 801, 802, but if you do it in full motion, you see him go just like that. Pulls his zipper down, he even gets off the camera. So away from people. He pulls his zipper down, he walks over, and he grabs it like that, and that's exactly what Jalen Leroy told the police that night. I saw him reach, I had no choice but to fire, and that fire was shot right there. Jalen Leroy throws down his gun. He says, I did it. Police come over. He throws down his gun. He testifies at trial, did exactly what I was supposed to do. I said, here's the gun. I shot this guy. I'm the one that did it. Goes down to the station, says, this guy came up to me. I had no idea who he was. He was mean mugging me. If you look, he's staring at him. There's no pleasantries exchanged. There's no smiles. The state mocked the totality of the circumstances, reasonableness in this closing argument, saying, oh, smile, he must have meant to kill somebody. Or he had his hands in his pockets. That must mean he wants to do evil. He did. This guy was preparing to do something to Mr. Jalen Leroy, and I think I have an innocent client right on that video, and it was never presented to the jury. And
What do you
that's
mean?
why
I thought you said it was all played to the jury.
The argument.
the actual narrative of what is on there.
But you're saying the lawyer didn't present it. Well, why is that not a 3850 case down the road?
Hopefully it won't be, but it surely has a.
Well, I mean, hasn't the Supreme Court kind of basically said that's the route that has to be gone now? We'd no longer reverse on direct appeal under a...
Unless it's blatant ineffective assistance, you first have to prove fundamental error, and then you can, dovetail into the ineffective assistance of counsel. But here,
You
Your
think
Honor,
that's what Steiger says?
yeah,
Go ahead.
here, either it's under a JOA, sufficiency of the evidence, or a fundamental error. I argue here, that's clear as day. And here's
Clear as day what?
that this guy was planning on doing some violence, and he zipped down his zipper to get the inside of his firearm, and it's right on the video, and no one's ever seen it until we're seeing it right now. Or
Did
at
your
least they
client
know.
ever say he saw a gun come out of him?
That's a good question.
Thank you.
Yeah,
Does he?
Does
he does a trial, yeah. So during his initial interrogation with the police, he says, why are you reaching? Why are you reaching? He doesn't say he saw a gun, but then after he watches the video, he testifies at trial, and he says he saw the butt of the gun. And so the state obviously tried to say that he's making it up or something, but he did.
Is that an unfair argument for the state to
Not at
say
all. Not at all.
at trial, saying he didn't say that before, now he's saying it now as he's thinking
I would
about
argue
it
the
at
same
trial?
thing, Your Honor.
Okay.
Yeah, but here's where the case goes off the rails. That is really close. And if the defense attorney would have brought the zipper, I think it probably would have been an acquittal and not a manslaughter. But the point is, this state attorney knew it had a weak case.
If it was really and I'm gonna follow up in just a second.
Yes, sir.
If it's really close, that's what a jury's for. You agree?
Absolutely.
All right.
And that's why.
So is the thrust of your argument, as I'm listening to it today, that what you contend to be improper argument of the prosecutor so fundamentally eroded the trial that reversal is appropriate because the video, because it was such a close call on the video?
You got it, Your Honor. And here's the fundamental error is not only to vitiate the entire proceedings, right? Fundamental has different definitions: to poison the minds of the juror, to cause them to not be able to compassionately deliberate.
Well, just so we're clear then, you're saying your best argument today is your second of the three arguments you've made in your brief?
I think the first and the second, Your Honor. I think the judgment of acquittal, the sufficiency of the evidence. I understand this court cannot reweigh the evidence, but this court must take a look at all the evidence, and if the evidence leads to no reasonable conclusion that this is fundamental error, this court can reverse on that, and that's why I showed the video today, to give the court an understanding that this is a problem.
You're saying as a matter of law that was self-defense?
I think
Isn't that what a JOA is? You're saying construing all the evidence in favor of the state as a matter of law, this was self-defense and the defendant should be acquitted? Tell me where I'm wrong with saying that.
You're not wrong. That's the law.
Well, you weren't saying that.
Yeah, no, you're right, sir. But what I am saying is this was a reasonableness inquiry, and this reasonableness inquiry was poisoned by the state.
Well,
And
That's what I'm saying. So you're saying the problem here is because the prosecutor committed such egregious errors or improper commentary in closing, we should reverse under a fundamental error because nobody objected to anything the prosecutor did.
that's one.
Well, I know, that's the second one. But I mean, the first one is you're saying it's a matter, the JOA should have been granted. But you're saying it's a close call, and as Judge Saub correctly points out, if it's a close call, that's why we have juries.
It's not now. That zipper is clear that that guy was planning something, and I'm into my rebuttal. I will save it. But Your Honor, I don't think that's clear. I think that is the smoking gun with somebody pulling down their zipper, and if you watch him approach, that zipper was up. He is preparing, and there's no other reason to do that. And Your Honors get to evaluate the entire evidence of this record, and that's why I wanted to show this video so Your Honors understand.
Evaluated in the light most favorable to the state.
And the state didn't even, and the detective didn't even watch this video when they arrested my client.
Go ahead. It's at the trial. The trial evidence, the trial judge denied the JOA motion. You're saying that's reversible. When we look at the evidence from an appellate review standpoint, we have to construe it in the light, according to the Supreme Court.
Yes, sir.
We have to construe it in the light most favorable to the state, that the verdict is proper.
Yes, sir. And
I mean, as long as we're communicating, we seem to communicate but not really communicate.
I'm trying to communicate with you. I understand, Your Honor, and I think my point is, with this
But
video...
that's the law. That's the law we have to apply. It's not a matter, I mean, you can, yes, we see the video, and you're saying the comments by the prosecutor were so egregious that it was an unfair trial and it should be done over.
Yes, sir.
That's your second argument.
Yes, sir.
That's your best argument.
I think the second argument is the best argument with your pointing out. But, Your Honor, I still think in light of most favorable to the state, I think that is, I mean, when I saw that,
We're not the jury, though.
yes, sir, but
You're arguing to us like we're a jury.
Yes, sir.
You've got 3.5 minutes
I'll-
if you'd like to say that.
I will wait and finish the rest of the rebuttal. Thank you.
Good morning. May it please the court. My name is Darren Shippey. I represent the state of Florida in this matter. Let me quickly address a couple things that were brought up by opposing counsel. I happen to be the lawyer for the Florida Supreme Court on Steiger. He got it wrong. I don't know that I need to say a whole lot more.
No.
Justice Lawson was the lead justice in that case, wrote the opinion. I'm quite familiar with what it says, and
So we are too.
okay, good enough.
3850 is for 3850.
That's
Not a direct appeal.
very good. They throw out stuff such as the victim in this case, Mr. Marquise Allen, was a two-time convicted felon. What he conveniently left out was that didn't come before the jury. It's in the record because the state was attempting to keep out certain things and, in fact, kept that out as well as trying to keep out the gun. So referring to something that the jury didn't hear in support of your argument why a JOA should have been granted, it's a little disingenuous, and I want the court to be aware of that. Same with the testimony of Destiny Harris. Yeah, that's what she testified to, so the jury heard it. Trouble is that the defendant, Mr. Leroy, he didn't hear it. So you were right as far as what was discussed, if anything, when Mr. Harris comes back and has a brief conversation, to the extent you can call it a conversation, with the defendant. But none of that was relayed to Ms. Harris, if she's to be believed, was before Mr. Leroy, so it doesn't affect how he's perceiving things. The video that I would encourage you to watch is State's Exhibit Number 3. It's the shortest. It is a combined video, but it's only 1 minute and 47 seconds, and it has arrows pointing out who's who. And I guess the other interesting thing about what I've heard today is that it sounds like we're hearing a new argument that I don't recall was briefed as far as what was going on with Mr. Allen's hands, his pockets, or whatever. We do know that the record is clear that the gun that was recovered from him, that the defendant did not know about, was in an inside pocket, didn't have ready access to it. So once again, that was a little bit overlooked today, and certainly undermines this notion that, oh my goodness, look what we saw in the video that no one else has ever seen. You know, one of the interesting things, and opposing counsel played baseball. I was a trial lawyer at one time, and tried over 100 jury trials. 20 of them happened to be murder cases, all as a defense attorney, interestingly enough. So I'm a little bit familiar with jury trials, how they work, from a defense perspective as well, including murder trials. And what counsel is essentially saying is put yourself in the place of the jury in this case. They got it wrong. 6 people who sat and listened to evidence, watched 3 videos, listened to the instructions from the judge as to how they're supposed to consider the evidence and what law that they were supposed to apply, and that they did because they in fact found the defendant not guilty of second-degree murder. We can speculate why, but certainly there was probably some questionable issue with respect to the second element of ill will, hatred, spite, and depraved mind, which probably doesn't show up on the video, so perhaps they got it right, but clearly, unquestionably, got it right with respect to manslaughter. The victim is dead. We know that because he died and someone testified about that. And that the defendant, and we know this from his testimony, his recorded statement as well, intentionally committed an act that resulted in the death. He doesn't deny he shot him. So
And those are the only 2 elements of manslaughter.
that's it. That's it. And interestingly enough, that I would want you to take into account is that defense counsel was pretty smart in this instance. Judge Sowd probably knows him from his time in Jacksonville, the Fourth Circuit, is that he argued against the jury being instructed on manslaughter. And that feeds into this notion of why his motion for JOA doesn't cover what they're arguing now on appeal. He wanted the jury to have to decide. It's either this ill will argument, and I'm arguing as a matter of law. That didn't happen. Jury, you can look at that. It's not ill will.
So the defendant's trial attorney did not want the lesser included manslaughter instruction?
No, argued against it, said it wasn't included in the information, overruled, jury's instructed on it. He wanted a all or nothing.
Wanted an all or nothing.
Absolutely, and it was a good strategy, except he wasn't supported by the law. He might have gotten what he wanted.
The state asked for the manslaughter.
Pardon?
The state asked for manslaughter,
Yes.
and they're entitled to ask for...
Absolutely, absolutely. And then argued that in perhaps, I think as well, the initial as well as the rebuttal closing argument, that there was this lesser included, even though defense counsel said disregard it, doesn't have anything to do with anything, this whole thing's a big whatever he called it, which kind of feeds into, well, first of all, this is a JOA claim that, and when counsel refers to a sufficiency of the evidence, that's wrong. It's not a sufficiency of the evidence. Is there sufficient evidence to support a verdict that you would be looking at in a different light? The issue in this case, is there any evidence? That's what the case law says. I didn't write it. You guys do. Any evidence that supports the case going to the jury. And there's a plethora of it. Whether it's the testimony in this case, the defendant's own statement, the law enforcement. If you look at the JOA from the perspective of after the defense case, the defendant's testimony, the testimony of Jacquez Harris about what he said, what he didn't say. The videos, clearly create a jury question in this instance about whether or not there was sufficient evidence to show that the defendant...
Was there testimony that the interaction was not harsh?
Yeah, that's the testimony from Jacquez Harris. Well, when you say harsh, you're probably going to rely upon the witness who testified, whose name, for whatever reason, is escaping me, testified for the defense. There were 3 witnesses for the defense. Bedard, the expert, the defendant testified.
There was no threatening, there was testimony, there was no threats back and forth before the shooting,
That is correct. And let's also be clear.
which the jury can then either accept or reject.
That's actually one of the arguments I used to make in closing argument. You get to decide what the evidence is reliable. The state can tell you to rely on this. I'm telling you to rely on this. I'm telling you to reject this. I'm telling you to reject what the state's telling you. That's the standard argument for trial work. So Jacquez Harris, the guy that didn't get shot, he's in the black outfit, he did all the talking to the extent there really wasn't any talking. According to his testimony, it's what's going on, what's up. Yeah, he's the guy. He's the guy that he's engaging with. The guy who gets shot and killed, he doesn't say a word, and this is from the defendant himself. I believe it was in his recorded statement as well as in his testimony. He did not pull out any object. He did not point a firearm, and he did not make any demands. So he doesn't say a word, but yet he's the guy that gets shot and killed. Sound reasonable? Absolutely not. And at least it's a jury question on whether or not shooting someone with his hands in or close to his pockets, who's looking at you, who's moving, along with every other person in the world that's in Jacksonville at that time of year for that football game, is moving. Is it reasonable to shoot him and kill him for doing
The
nothing?
defense takes the position that he shouldn't have to wait like the old Wild West days till everybody pulls their guns, right? He basically said, I figured that's what he was going to do, and he didn't see the gun, but later on, lo and behold, he did have a gun in his jacket, and whether it's zipped down, he's reaching in his pockets, whatever. I mean, there is that, and I understand the jury was not advised of the gun. Is that correct or not?
They did not hear about the gun. Well, no, they did hear about the gun. I take that back. They
Okay,
didn't
they
hear about
moved
the
in limine,
convictions.
but-
They didn't hear about the convictions, that he was a
Okay.
two-time convicted felon, wasn't allowed to possess a
State
gun.
moved in limine, but the judge
They moved in
finally
limine to
denied
keep
that.
out the gun. Judge overruled, the gun comes in. Trouble is the defendant didn't know about it.
So the jury knew that the decedent had a gun,
Yes.
in
they
the
did.
context of them evaluating whether this was self-defense.
They did. Yes, they did. Absolutely. They knew it. And they still rejected it. So
And they would have seen what the soon-to-be decedent was doing, knowing he had a gun.
They
The
saw
jury
thr-
knowing that guy had a gun and how he was moving his hands in his pockets and stuff like that, the jury would have seen and heard that and had to make the call based upon the instructions given by the trial judge.
they saw just what you saw, as well as the short Exhibit 3 that I'm encouraging. If you have any questions, to watch that one. That's the one that gets you right to the heart of the matter really quick. That one's, I've got them written down ones.
We don't know what the jury discussed back in the deliberations of, did one or two of them go, hey, look, his jacket's unzipped now? We don't know that, do we?
You don't know, and that's why you ought to leave the jury verdict alone. You weren't in there. You're not, your goal, your purpose in this process is not to insert your place into the place of the jury. They get to make that call, and we ought to be respecting the jury's verdict in that regard.
It sounds like your opponent here today, his primary argument, even though he seemed to grudgingly want to say it, was his second argument that, this is a close call about whether it was or wasn't self-defense, but the comments by the prosecutor in closing argument, the unobjected to comments were so egregious that this just made the overall trial unfair and there should be a new trial. That's as I understand, paraphrasing his argument as to why this should be reversed.
I think he's defaulting to that. I think he's in love with the video that he saw, and he wants you to find that there's no way that anybody could ever find that he wasn't acting in self-defense. But listening to your questions, I think he acquiesced to you. I don't recall if you were on the Antoine Stafford panel.
Can't recall.
I happened to be on that case as well. That's the one that the defense loves in this case, because it turns out that one of the prosecutors in that case was one of the prosecutors in this case. And this court reversed in that case based upon a fundamental error argument, based upon closing arguments. The facts are dramatically different in Stafford from this case. That was,
Statements are different too, if I recall, on that case.
in my opinion, yes. But they're picking out what they want and what they think they can pitch to this court. But it was a drug case, trafficking case, and the evidence was weak. As I looked at the case from my perspective representing the state of Florida, I was concerned about the sufficiency of the evidence because they didn't have anything on this guy. They went in, questionably or unquestionably so, found drugs that were hidden underneath back porch, secret areas and stuff like that. Could never really connect it to the defendant in that case. So that is remarkably different from what we have here, which is you don't have to guess what was going on. You have the testimony in this case, but you can set it on one side here and rely upon it to the extent it's necessary. But look at the videos. The videos. And once again, this idea that we get to judge or that we're stuck with the defendant's viewpoint as to whether or not he had a reasonable belief. That's not the standard. We have a reasonable standard because we'll take into account what you say, what you felt, what you thought, which is you have to actually have that belief actually before you get the jury instruction. But we're going to set that aside and we're going to look at it from a reasonable person, an objective standard, and then we're going to apply that to what you thought. And in this instance, it fails miserably for the defense, miserably.
Do you think some of the comments that were made by the prosecutor were inappropriate? I mean, I know they were not objected to, so we go to the very tough fundamental error standard that's very hard to reach for a defense.
So I didn't concede in the brief, and I don't concede before you that they were error that would have warranted an objection, and that can be a little bit of a stretch. I'm going to get to your answer too. Defense lawyers have a strategy about whether they're going to object to certain things in a closing argument or whether they're going to get up exactly like what the defense counsel did in this case and say, he said this, and you know what, you're not going to find that. Judge is not going to instruct you of that. And then you'd weigh that whether or not that's the better way to deal with it. And in this instance, he weighed it based upon his experience that he didn't feel the need to object. So the preemptive one is, self-defense, and I've gotten to where I don't even call it that anymore. It's, am I justified in using deadly force? And that takes me out of this context of I'm
It's
defending
actually the
myself.
title of the instruction, but...
It's
yeah.
exactly right. And when you stop and think about it in the terms of, am I justified, me personally, justified in using deadly force as a matter of law, is shooting a gun, am I justified in doing that? Then it makes you think about it, and it's like, well, I have to have some objective reason for doing what I did, which is to shoot somebody who didn't say a word, who didn't pull out a gun, who didn't point anything at me. So when you use the word preemptive, and you can't shoot and ask later, so they get that argument from Bedard, their expert witness, who trains law enforcement officers. Law enforcement officers, and that's all he trains. He's not out there training the public. He's not there telling them what to do. He's training law enforcement officers, look, got any doubt in your mind? Shoot first. We'll sort it out later. You shoot first because if you don't, you die. That's not what we're going to apply to our society, though. And that's not what the legislature contemplated when it drafted the statutes in 776.
What do you think? The comment, your opponent today was talking about the conscience of the community argument, and I think it's referring to the argument made by the prosecutor in closing, quote, if that were the way that reasonable, rational people conducted themselves, bodies would be dropped all over that night. Is that behavior cautious and prudent? Is it reasonable? Is it rational? No. Defendant contends that's an improper conscience of the community argument condemned by multiple appellate courts.
So what I did in the brief and the way,
Yes, I guess.
I'm sorry, didn't mean to interrupt you, my apologies.
Go ahead, no, go,
Okay.
I'm done.
So the way I address it in the brief is we don't get to cherry pick and pull out and set them over here on the side, and those are the statements, and let's make a long list of those. I think you have to put them in the context in which they were said, which is what I did in the briefs, much longer, where there's a lot of things said in there, such as he does not have the duty to retreat. It has to be a reasonably cautious and prudent person standard. It has to be an objective standard. So I think when you throw it all in the wash, so to speak, and you mix it all together, then I think the impact that it has on the trial is lessened and minimal compared to if that was the theme of the argument. But both prosecutors were good in both the initial as well as the rebuttal closing in addressing what the jury instructions were going to be. And perhaps more specific to what you're saying, would I counsel anybody to make those arguments now that I'm an appellate lawyer and I have to deal with it on appeal? Stay away from it. But is it error?
Well, here is it fundamental error. Yeah.
True, I was just going to get to the point of error, but is it fundamental error to the point that it vitiated the entire trial, to the point that based upon all of the evidence in this case, because remember, the closing arguments are not evidence, the jury specifically told that, we presume that the jury follows the law unless there's something in the evidence showing us to the contrary. All of the evidence in this case, you're telling me that the jury is going to disregard that and they're going to latch themselves on to these isolated statements that when you put them in their fuller context really kind of get watered down and don't have the impact that they do. So with that, I've got a minute left. I'm going to leave it at that. This is unlike what counsel would suggest being a close case. It's the opposite. Go 180 degrees the other way. It's not close at all. You should affirm. Thank you.
Respectfully, I think the video shows exactly how close this case is. And when you come down to the fundamental error of closing argument, Judge Lambert, I wasn't evading your question. I did think it was a good issue, but I'm going to stick to fundamental error because of this. Fundamental error is a hard burden to reach, but when you're dealing with reasonableness and the jury deciding whether that was reasonable, here's what the state said. If it's reasonable, bodies are going to drop in your community. This is not how we act or we intended to apply the law. First thing anybody is going to say is, I thought I was in fear. So he's setting it up. He's giving the prosecutorial expertise, the community knowledge. There's no statistical evidence backing that up. The first person, if you shoot somebody, the first thing we're all going to say is, I acted in self-defense. And then he says, self-defense sometimes exists. So now he's giving another statistical probability based on his prosecutorial expertise that he thinks that he's telling the jury that we're only going to find self-defense sometimes in this world. Then he says people that are charged with crimes build narratives of self-defense, usually falsely. So he's telling the jury this is hogwash. People that do this stuff don't buy it. And then I get into the smiles. He disparages the totality of the circumstances that the jury has to look at. Oh, he's smiling. He must mean he wants to kill him. And then, of course, the can't shoot, ask questions later. So he is misleading the jury, giving a misstatement of law on the defendant's sole defense.
Doesn't the Florida Supreme Court basically tell us, through us and then to you, that, look, if you think a prosecutor is saying things that are wrong, is going off on a bad track during closing, object, let the judge straighten everything out so we don't come back later on after the fact and say, well, look at these 7 bad things he said, and therefore the totality of the circumstances reaches a fundamental error. And that, as you have to acknowledge, as you did in your brief, that wasn't done here. If it was so egregious, it could have been brought to the attention of the judge early on, and then we wouldn't be having this discussion. Your client may have been acquitted. I don't know. We don't know because the jury watched what they watched, and they heard what they heard, and they were instructed. But that's Supreme Court basically says everybody needs to do that, and that this is not something they just created 6 months ago.
I don't know why the attorney didn't object. That's on the attorney. I don't know, but the argument I have here, Your Honor, is
Well, you have, the facts are the facts that you have to deal with on appeal.
Yes, sir.
There is no objection, so it can't be, it's not a preserved error.
Yes, exactly.
We get it. Yeah, we understand.
And the point here is when the decision is solely based on whether this is reasonable, this is a poisoning of the minds, because he took reasonableness out and he told the jury, you're going to be in the grocery store and bodies are going to drop if you find this is reasonable.
I mean, for your position basically has to be, but for those comments of the prosecutor, this gentleman would have been acquitted. Doesn't that have to, isn't that, it's so vitiated the fairness of the trial that the result is unreliable?
It is unreliable.
Because of the comments of, you know, so in other words, the reverse to that is if this prosecutor didn't make any of these kind of comments, then however it would have, whatever the jury would have done, they would have done, and
played out. I'd like to point out one more thing. In the state's brief, they pointed out in an argument why this should be affirmed that the detective on the stand said that he didn't believe the defendant's point. So even the jury's being told by the detective, which of course is high-level error of invading the province of the jury's sole fact-finding.
somebody object to that?
Nobody objected to that.
All right,
Thank
thank
you.
you. We'll be in recess.
All right.